Hi, Chuck Gadway, Coldwell Banker, and with me today is Deb Cavender with Guardian Title. And Deb, my question now is, when a client, a buyer, seller, get the paperwork, the title work back, what are they supposed to do with it? How can they understand it? What are some of the red flags maybe that they should be looking for?
Excellent. Good question. The buyer is actually the one that's probably going to spend and invest the most amount of time, Chuck, on a title commitment. For the seller, I'll cover that first because it's relatively quick. We want to make sure that the seller looks to see that whoever has executed the listing agreement and the contract on behalf of the transaction is also the party of interest that owns the property. Sometimes people will have name changes, or they'll transfer title from an individual to a trust, or there might be a deceased party in the transaction. And on the title commitment, it defines a public record who's the true owner of the property. Not that we can't work through all of those unique circumstances, but if it doesn't match exactly as to who's going to sign the contract, title is going to need some further documentation. So I would, as a seller, really take a look and make sure that how it's vested currently, which is on Schedule A of a title commitment, matches exactly how they're signing the contract and the listing agreement.
Okay.
You also want to take a little peek at the purchase price, because they want to make sure that the title commitment is ensuring what they knew to be their purchase price or the sales price of their home. The requirement page of a title commitment identifies what liens need to be paid as part of a transfer of title. And these are often liens that would be specific to a mortgage of first or second. It's not uncommon, it's rare, but it can occur where perhaps the title commitment won't reflect all the proper liens of records. And that could be because it was recorded in a wrong county, or perhaps a lender just missed recording that deed of trust. But that doesn't mean that the seller might not owe the debt. So what we do encourage them to just take a look at those requirements. They're called the release of deed of trust. Those should match what they know that they have outstanding obligations or loans against the property for.
Okay.
So that's pretty simple for a seller. For the purchaser, it's much more important, because this title policy or commitment will insure them for the ownership of that property. And so they also want to make sure on Schedule A that their names, as they intend to take title, appear properly, and that it also tracks to how they're actually applying for a loan application. Because what the lender shows on their records needs to match how we're going to vest ownership or transfer with a warranty deed. So they want to make sure that that's how they want to take title. We recommend, if you use a middle initial, that you use middle initials in taking title. The more information that you can provide, the more accurate and clarity it provides with public records and true ownership.
Okay.
The other very important part of the transaction is in what's called the Schedule B exceptions. Exceptions, we talked a little bit about some of those, not all, but some of them are insured by purchasing the owner extended coverage policy or endorsement. But there are other items that are stated on that page. They tend to fall more towards the bottom of that page that speak to items that are of public record that impact the property. It might be a right of easements or claim of access for a public utility. It might be a filed oil and gas lease that may or may not transfer with the interest of the property. One of the more common ones that we see is the covenants, what we refer to as CC&Rs, which are your covenants and restrictions on the property. Those are stated, filed restrictions and information that really govern what you can do with your property. Sometimes they're linked directly to a homeowners association with dues. Sometimes they are just recorded covenants. It might tell you what colors you can paint your home, how many chickens you can have in your backyard, what your restrictions are for perhaps parking and RV, those types of things. So those covenants are very, very important. And that's an area that the homeowner or the purchaser really needs to read through those, because if they have questions, title's job is only to disclose, not to interpret many of those items. So what we do is we provide them the actual recorded documents of public records that impact their home. We also advise our agents, yourself, not to be the expert in providing legal advice or direction or advice on those items. And the reason why is that there may be something there that an interpretation could be miscommunicated or misunderstood, and we don't want you liable for that interpretation.
Appreciate that.
So first thing we suggest is, if they do come to you with some questions regarding those exceptions, encourage them, first of all, to read through the information, make their list of notes, and then have them contact one of us at your title
Okay.
company. We're happy to assist them. I can tell you that we're not always the experts, but I have a chain of people that I can go right up onto our legal staff that can provide information if there's great questions or concerns. Now, sometimes we have to refer them back to their own legal counsel, because if they're trying to interpret an oil and gas lease, we are not able to provide legal advice, we can only provide information.
Okay. Sounds good, thank you
All
very
right.
much.
You're most welcome, thank you.